Welcome, friends. Today's topic is Articles of Association. Articles of Association is one more important document which is required at the time of formation of the company. When we incorporate the company, various documents we attach. Two documents which are extremely important, which needs to be uploaded at the time of applying for incorporation of the company. One is Memorandum of Association, second is Articles of Association. Memorandum of Association, this is there are various points, or you can say various clauses contained in that document, like company's name, company's location, that is the situation, then company's objective, company's capital, company's liability, who are the subscribers. All these things are contained in that document that is called as Memorandum of Association. Coming to Articles of Association, this is another document where the internal management of the company, how company can be internally managed, those things are drafted, those things are written. So let us have a look at that document. First of all, let us see what should be the format of that document. So for that thing, let us visit to Ministry of Corporate Affairs website. We'll see the formats of Articles of Association. Okay, let us visit there first. So I'm taking you to MCA website right now. Give me a second for that. Are you seeing the screen right now? What are you seeing? What are you seeing right now? Could you please tell me? Google browser you are seeing? Now I am taking you to the mca.gov.in. This is the website I am taking you to. Right. So we have already visited to this website. You see, this is the Ministry of Corporate Affairs website. And since we want to know about Articles of Association, I would like to take you to the ebooks. Here we can go through ebooks. Otherwise, we can also do one thing. We can go here, Acts and Rules. We can go to Acts, right? Acts and Rules. Here you see links are there. Companies Act 2013. I can see it here. And you see, this is the Companies Act structure, which is appearing in the left-hand side. Various chapters are there already, and once the chapters are over, then the schedule starts. And the schedule 1 talks about table A, table B, table C, table D, table D. I will taking you to table F. Okay, which table? I told you table F. Are you able to see it?
Yes, sir.
So let us watch now table F. Table F you look. Now you see what is here. This is an Articles of Association. So this is, you can say, this is a model article. Okay, this is the Articles of Association of a company limited by shares. This talks about, first of all, about interpretation, how this can be interpreted, share capital and voting rights. So that those aspects are discussed here. Okay, then you see lien. Okay, then all these points we'll be discussing. Calls on shares, how a share can be called for. Transfer of shares. Transmission of shares, how shares can be transferred, how shares can be transmitted, how shares can be kept as lien. So all these points are, you see, this is, now you must be knowing, this is about internal management of the company. How shares can be forfeited, in which situation shares can be forfeited, meaning it can be cancelled. How capital of the company can be altered, alteration of capital. How profits can be capitalized. Okay, profit can be capitalized and bonus shares can be issued, like this. How shares can be bought back, buyback of shares. How general meeting can be held. How proceedings of the general meeting can be recorded. How meeting can be, in which situation meeting needs to be adjourned. What is the voting right of members? Okay, if the member is unable to attend, whether he can appoint a proxy for him. How, what will be the constitution of board of directors? Who will be in the board? Okay, how proceedings of board of directors can be maintained and recorded? Okay, description about the CEO, manager, company secretary, CFO. How seal of the company can be used. Okay, how to pay dividends, what is the process for that? and to what extent reserve can be created out of the profits, how accounts can be dealt with, how company, if you want to close the company, how this winding up process will be followed. What is the indemnity clause if somebody incurs some losses, how that can be indemnified. Okay, then these are the various points which are included in the articles. Articles of association. Did you get some basic idea? That means this entire document talks about internally how we'll be managing the company. Okay. Yes or no? Are you getting?
Yes, sir. Yes, sir.
You get it? Now,
Yes, sir.
now let me show you the slides. We'll be seeing practically some other articles of association also. Now let us first we'll cover the content. You see, what is articles or articles of association? It is defined on section 2, clause 5. It says article means articles of association of a company as originally framed or as altered from time to time. That means it's not necessary that articles of association which is once let us say registered, that is final. It can be altered from time to time. Okay, so there is a possibility that articles of association can be amended. And in that case, when you're referring a particular, when you're referring the term articles of association, that means it may be the original AOA or which has been altered from time to time. And there is, you see, one more point, it says or applied. Applied means in certain situations, if articles of association is not there, then I had shown you some model articles of association. Just now we saw it. So that can be applied. Okay. If the company doesn't have, then a particular table may be applied. That is called, that will be also treated as the articles of association. So it may be original articles of association. It may be altered articles of association, or it might be applied articles of association. Is it clear to you?
Yes, sir.
Okay. This is the meaning of articles of association. Here you see E articles of association. I will show you complete E articles of association. Just give me a second. Give me 1 second. I'm trying to show you. Just like previous session, we had seen the E memorandum of association. Let us see one E articles of association. Yeah, we got it. This is, you see, E articles of, okay, you are unable to see it, right? Just a minute. Are you able to see it now? Just give me a second.
Yes,
Yes.
sir. It's really-
Yes.
You see, this is again a spice form, E articles of association. You see, this is the table F as notified in the Schedule 1 of Companies Act 2013 is applicable to the company. Now you see, first it talks about interpretation, how various terms can be interpreted. Sorry, for example, when the word act is there, act means Companies Act. When seal is there, that means common seal of the company. So this is how interpretation part is discussed. Okay, it's the AOA of a company. Share capital and variation of rights, that part has been discussed here. Okay, lien, how share can be kept as a lien, that is, those points are covered here. Then you see calls on shares, how shares can be called for. Suppose maybe first call, second call, like this share capital money many times called in lots, called in installments. So how it can be called upon, how shares can be transferred, in which situation it can be transmitted, forfeiture of shares. Okay, shares in which situation share can be forfeited and what is the procedure for that. Alteration of share capital, this also you see. Okay, all these things were there in the table A. The table F, is it? You see, this is the actual article participation. You think similar things are also there. How profit can be capitalized, buyback of shares, general meeting, proceedings at general meeting, adjournment of meeting, voting rights, proxy, board of directors composition. Okay, so these people will be the board of directors, that names you have to write. Proceedings of board of directors. Okay. Yeah, are you able to see it now?
Yes, sir.
Yes.
Yeah, I think there was some connectivity issue in between. Now you see. Yeah, so accounts winding up, all these points you see, which we are seen in that table, are discussed, are written here. Finally, just like memorandum was subscribed, here also this is subscribed by the subscribers of the articles. Okay, or you can say by the promoters. You see, these are the directors, their dean, their place, their addresses are also there, their digital signature. They have subscribed to this article. And this also needs to be declared, that one declaration from a professional is also required, that all the requirements of the act have been complied with. This is also one more requirement. Right? Did you understand how articles of association looks like?
Yes, sir.
Okay. Now, so now at this stage, we can understand that the entire document, the document of articles of association, talks about internal regulations of the company, how meeting can be conducted, how shares can be transferred, in which situation it can be transmitted. So all these things are discussed in this particular document. And this is subordinate to the memorandum. Memorandum, you know, that is a very broad document. Company cannot do anything beyond memorandum association. If the powers are not there in MOA, then company cannot do any activity. Okay, so the object clause in the memorandum is very important. But this document is subordinate to the memorandum. When memorandum specifies these are the activities has to be done, but how that can be executed? How that can be executed? Only when the company will be internally managing various things. That internal management things are discussed in this document called as articles of association. A public company may or may not have articles of association. If it doesn't have, then it will adopt table F, which is there in the schedule 1 of the act, which we just now we saw. Right? We have already seen. First we saw the table F, then I saw you practical articles of association. So articles of association, a public company may not have. It can manage without articles of association. Therefore, when we learn the definition, what we have seen, articles of association as originally framed, as altered, or as applied. As applied here means table F applied. And company is expected to print it on a foolscap paper and shall be signed by subscribers to the memorandum. The persons who had signed the memorandum of association, those persons also need to sign this document called as articles of association. Is it clear at basic level?
Yes,
Sir,
sir.
Yeah,
sir, a small doubt. That
yeah, please.
subscribers is not subscribers, or what does it?
Sorry, what you're saying, subscribers?
Sir, thoda details. Subscriber, what does it mean, sir?
Subscribers means, you see, That means, you see, they are subscribing the memorandum, means they are agreeing to all the terms and conditions, all the points which are there in the memorandum. That is why they are subscribers. Okay, that is one sense of understanding that. Other way of understanding that is that they are also ready to subscribe the number of shares which are mentioned there. Those many shares they will be subscribed.
Right, sir. Okay, sir.
Okay,
Thank you.
understood? Two ways you can think in two ways. One is that these are the people who are initially forming the company. In future, many more sets of shareholders may come. But initially, these are the people who has given commitment that they'll be subscribing these many shares of the company. And you must have seen against their name, number of shares where these many shares they'll be subscribing. Okay, that is the subscription of shares. But when you are saying subscriber to the memorandum, subscriber to the article, that means all they are agreeing to all the points which are mentioned there. Okay. Okay.
Yes, sir.
Yes.
Now, next point. Achha, what are the contents of articles of association? We have practically seen what are the contents of articles of association, like how shares can be transmitted, what is share warrant, general meeting, common sale, etc. So, no need to show you the list. Rather, we focus on the provisions of the law. You see, the section 5 talks about what should be the content of the articles of association. First point or the first subsection is articles of association of the company shall contain the regulations for management of the company. How you are planning to manage the company, that is contained in articles of association. It shall also contain such matters as may be prescribed. If law prescribes some points should be there in the articles of association, then it should contain that. Okay, but there is a proviso also, provided that nothing prescribed in this subsection shall be deemed to prevent a company from including such additional matters in the articles as may be considered necessary for its management. This means if the management wants, that it may definitely add some additional matters. Law has nowhere restricted that these are the only things you have to prescribe. Nothing more can be prescribed. Okay, so additional matters, if it is felt necessary by the management, that also can be put in articles of association. This concept is clear to you? Yes or no? Are you getting me?
No, sir. No.
No,
Sir,
not,
please repeat.
yeah. So
Please
you
repeat,
see,
sir.
yeah, section 5. Now we are only 2 points or 2 subsections we are discussing. First of all, it contains the regulations of the management, regulation for management of the company. So no issue here. We have seen it talks about how meeting can be regulated, how share transfer can be regulated, how
Yes, sir.
share transmission can be regulated. That is one part. It talks about regulations for the management. Second thing is that it also contains the matters as may be prescribed. So if law prescribes certain things should be contained in the articles of association, it should be there. Is it not? So you have already seen when you have studied, you see the definition for private company. At that time, what we have understood, that there should be some restriction in that. So law specifies if you want to form a private limited company, a private company, there should be some restriction as regards to transfer of shares, as regards to maximum number of shareholders. That restriction should be there. Okay, so if something is provided in the law, that also should be contained in the articles. Is it clear to you?
Yes, sir.
Okay,
Yes.
but next point is that this does not mean that you cannot add anything more than whatever is prescribed. Definitely that should be there, but you can add more terms also. So there is no restriction that you cannot add anything beyond this. This is the format, exactly that thing you have to write. No, nothing like that. If you want, you can add more points. Is it clear to you?
Yes, sir.
Okay, so
Yes,
that is the point, that is the proviso to subsection 2. Now, let us move to the third point. The article may contain provisions for entrenchment to the effect that specified provisions of the article may be altered only if conditions and procedures as may be more restrictive than those applicable in case of a special resolution are met or complied with. Oh, you might be finding it difficult to understand this. Is it not? So legal language is like that. So we'll try to simplify it. Did you understand? Anything from subsection 3? Little difficult, is it not? It's difficult. But first, let us understand. You see, article may contain a provision for entrenchment. To understand this, first of all, we need to understand what is the meaning of entrenchment. Entrenchment means making something more difficult. Okay, making something more difficult. That means creating some restriction, so that normally that thing may not happen. Suppose the provisions in the article is that articles of association is that this clause can be altered by following a particular process. We can alter this thing. We can make it more strict. Like this, suppose we can say this cannot be altered unless a special resolution is passed. So by adding this provision, what you are doing, you are making the process more difficult. Is it not? So this process of making things more difficult is referred to as entrenchment. Did you understand?
Yes, sir.
Okay. So this particular provision says that it is possible that you may add some entrenchment. It may contain provisions for entrenchment. That means more restrictive provisions can also be created. Now, point 4 talks about, or subsection 4 tells about. Give me 1 second, just 1 second, just. Let me mute. Mr. Amon's mic is on. Yeah, now I think clear. Yeah. Now, if you read clause 5, the provisions of entrenchment referred to subsection 3 shall be made either on formation of the company, at the time of formation of the company, when you are creating the original articles. At that time, this entrenchment can be created, or by an amendment in the article. Subsequently, articles can be amended. But when you are amending the article, you have to see agreed by all members of the company in case of a private company. If it is a private company, then each and every member needs to agree to the entrenchment. Okay, meaning you are creating a more restrictive provision. Each member should agree to that. And in case it is a public company, then all members need not agree, but at least a special resolution will be passed. Okay, entrenchment can be created in the articles. That means articles can be made more strict or more restrictive. Okay, and that can be made at the beginning itself. Or if you don't want to make it beginning, you want to initially register an article. After that, you want to get it amended. That also you can do. But you are amending the article. In case it is a private company, then we need approval from all the members. All the members need to agree to this kind of retrenchment. And if it's a public company, then all members need not agree. Only special resolution is sufficient. Special resolution means, first of all, notice must have been given to the members that a special resolution is going to be passed. Secondly, the resolution must be passed by 3/4 majority. Votes which are cast in favor of the resolution must be at least 3 times more than the vote that are cast against the resolution. If that is so, we can call that resolution a special resolution. And by passing a special resolution, this entrenchment provisions can be made. Understood this point?
Yes, sir.
Okay. So this articles of association is a little complex, so please bear with me. In case you have any query, then you may feel free to ask. Now, in case the company has where the articles, or you can let me read it fast, where the articles contain provisions for entrenchment. There is an entrenchment, whether made on formation or by amendment. The company shall give a notice to the registrar. Suppose company has purposefully made it more strict here. some of the provisions has been made more strictly. Then company need to inform it to the registrar of the company that these are the things we have done in the articles. Okay. For different companies, there are different prescribed model articles are there, like table F, table G, table H, table I, table J in schedule 1. So for different types of company, different article formats are there. So one may follow. You may please visit to the MCA website. You can find out Companies Act 2013. You can find out schedule 1 to it. And in the schedule 1, you can find out table F, G, H, I, J. These are the tables which refers to articles of association. Table A, B, C, D, E, they are relating to memorandum of association. A company may adopt all or any of the regulations contained in this model articles. These are in fact model articles. These provisions which are contained in those model articles can be adopted by a company. Hope it is clear to you. Okay. Let's move. Now, if a company is registered after commencement of this act, okay, after commencement of this act means after 2000, after this act, Companies Act 2013 was implemented, was commenced. Insofar as the registered articles of the company do not exclude or modify the regulations contained in the model articles applicable to the company. That means we are talking about the new company which is incorporated under new act, and that company has not specifically excluded or modified any regulations contained in the model articles. Okay, if that is the situation, it has not modified, then these regulations, those regulations shall, so far as applicable, be the regulation of the company in the same manner and as if and the extent as if they are contained in the duly registered article of the company. That means whatever is contained in the model articles, it will be assumed that that is also applicable to this company, unless this articles of association of the company has specifically excluded that. If it is not excluded, then it will be assumed that what is contained in the model article, that is also applicable to the company. Okay, this is for new companies, but this is not applicable to the companies which are registered under the previous acts. Okay, for new companies, even if it is not contained in their own articles of association, but if it is there in the model articles of association, it will be applied to them as if it is contained in the articles of association. That's the provision. Okay. Understood? The law relating to articles of association. These are the provisions. These are the law about articles of association. Is it clear to you? This is the contents of section 5.
Yes.
Having finished this, any query you have? Any doubt you have? Friends, we have seen articles of association. We have seen the model articles of association. And we also know what should the content the articles of association. Right. And we are now also, we know that what is the pronouncement of section 5, that's the law relating to articles of association. Is it clear to you? Yes or no?
Sir, it's clear, but it will take some time to remember all the steps.
Yeah,
But
yeah.
it is clear.
I understand this appears little complex because exact law we need to read and we need to interpret that thing. Okay. Otherwise, just like that, we can just say these are the content of articles of association. But we thought so. We thought at this stage, all of us should read the law. Okay. So you can refer to it. Videos will be made available to you. Slides will be also made available to you. So kindly read it again. Now, friends, now let us move to the next provision. Section 5 is over. We'll go to section 6. Section 6 of the Companies Act 2013 talks about one important thing. That means what it says, that the act means which act? Companies Act 2013. It says act will always override MOA and AOA. That means what? Meaning, if there is some confusion, or there is or MOA or AOA contradicts the provisions of the Act, then which will supersede? Act will be valid or MOA AOA will be valid?
So the act.
Act will be valid. Yeah, that is what is contained in next provision, that is section 6. So let us see what is the content of section 6. Let me show you that. Section 6. The title of the section is Act to Override Memorandum Articles, etc. etc. means any internal resolution, any contract. It says the provisions of the Act shall have effect notwithstanding anything in the contrary contained in the memorandum or articles of the company. That means even if something contrary is contained in MOA or AOA or in some contract, in some resolution, the acts shall have effect. Okay, act will be for effect. Amanji, yeah. Amanji, kindly keep yourself muted. I have muted you, but please keep watch on the mute button. Yeah, friends, this is what we are discussing. That act shall have an overriding effect. So even if company has passed a resolution or entered into the contract as per the MOA, but something contrary is prescribed in the law, then act shall override that. Act shall supersede. Okay.
Yes.
Okay. So this is the main essence. And of course, one more point is that any provisions contained in the memorandum articles of agreement or resolution shall to the state to which it is repugnant to the provisions of this act shall become or be void as the case may. If something is against the act or something is, let us say, not acceptable, okay, okay, in that case, that will be taken as void, even if it is contained in the memorandum or articles of association. If something is not acceptable, so act has made it clear that this is not possible, but still you are entering in the MOA and AOA, then that will be treated as void. Okay. Understood?
Yes.
Yes, sir.
Now, next concept we'll be learning effect of memorandum and articles. So once memorandum or articles are registered, it has got a binding force. That means all the members are bound by the terms and conditions, by the clauses which are mentioned in the MOA and AOA. It binds the company and the members. Okay, to the extent as if each one of them have signed, each one of them is agreed, but actually it is signed by subscribers one, but other members are also bound by the terms and conditions, by the clauses which are mentioned in the MOA and AOA. Okay, so all the provisions which are contained in the memorandum or articles needs to be observed. And since it has got a binding force, the next concept is that if any money is payable by the member, how money is payable? You know, members' liability is limited, but to that extent, money is payable. So money is payable as a member to the company under memorandum or article shall be treated as a debt. That means it will be considered is an amount payable by the member to the company. So it will be recovered. Okay, right. Suppose a member has subscribed a share and he has not paid the money which is called for. This is due to the company by the member. So this shall be treated just like a debt. Understood? This is again, this is how articles or memorandum has got a binding force. Is it clear to you?
Yes, sir.
Now, next concept is that section 14 is the alteration of the article. You already know from the beginning, articles can be altered. It can be altered from time to time. But as per the provisions of the Act and as per the conditions which are contained in the memorandum, articles can be altered. Okay, but how it can be altered? For altering an article, and special resolution is required. Okay, you need to alter with the help of a special resolution. Any company may, by special resolution, alter its article, including alteration having effect of converting a private company to public company or public company to private company. Okay, what is public company? What is private company? We had discussed in our initial classes. You know, what is private company? There are restrictions in the articles. Restriction as regards to transferability of the shares. Restriction as regards to maximum number of shareholders. Okay, if that restrictions are removed, that will become a public company. So by alteration, the restriction can be removed. If it is removed, private company can be converted into public company. And if these restrictions are added, then a public company can become a private company. So alterations are possible. Okay, private company can be made to public company can be made as private company. Okay, and the moment, now let us see the effect. One more point here. Where the company, being a private company, alters its article, that it becomes public company. So the private company, by altering article, becomes the public company. Then immediately that company will cease to be a private company. He will become public company. Okay, the moment he included, if they remove the clauses, remove the restriction from the articles of association, that will cease to be a private company. Understood? But if it is a reverse means what? Public company becomes a private company. If public company becomes a private company, it shall not have effect except with approval of tribunal. That means National Company Law Tribunal must give approval for public company to become private company. First of all, you need to alter the memorandum. You need to put restrictions which are required for private company. That is one thing. But in addition to that, approval of NCLT, National Company Law Tribunal, is required. After that only it will be effective. So public company to private company is little difficult. Okay, but private to public is easy. Is it clear to you?
Yes.
Okay. And if any alteration is made, then the altered article needs to be filed with the register. Okay, with printed copy, we need to file the printed copy of the altered articles within 15 days. And any alteration of the article registered under this subsection, subject to the provisions, are be valid as if it was originally in the article. Once it is altered and it is properly filed, properly registered, then it will be treated as if that was the original article. Okay. Now, section 15 talks about every alteration made in the memorandum shall be noted in the memorandum or the article shall be noted in every copy of the memorandum articles. So all altered provisions should be corrected in the memorandum and article. It should be noted. And if the company doesn't do so, let us say after that memorandum is altered or article is altered, but after that you are asking for a memorandum and you are given an old memorandum. If that is the situation, that means all the memorandums are not correct. In that case, the officer who is in default shall be liable for a penalty of 1,000 rupees for every copy of the memorandum article issued without alteration. So this is the penalty. So once it is altered, it needs to be corrected in every copy of MOA and AOA. Otherwise, the concerned officer has to face these penal consequences. Okay. Now, friends, next important thing is that what is the difference between MOA and AOA? So this is one point. So I am keeping it for our next session. Okay. The difference between MOA and AOA. And two connected points we'll be also seeing. This is about doctrine of ultra-vires, doctrine of constructive notice, all this concept we'll be discussing in the next class. With this, that concept will be closed. Okay, today we stop here. We got a very basic and broad understanding about what is articles of association, how it looks like, what is its importance, how it can be altered, what is the impact that we've seen. Broadly, if you say, memorandum is a broad document, primary document, and articles of association is again a subsidiary document kind of thing. It is subordinate to the memorandum. Right? So let us distinguish between these two in your next session. Any query you have?
No, thank you, sir.
Thanks a lot. Let's catch up in the next. Thanks a lot.
Thank you, sir.
Thanks.